And you are live.
All right, so we are calling this meeting of the Akron Civil Rights Commission to order. We have a agenda that was distributed with the notice of the meeting. Right at the outset, I'd like to welcome, we have a new commissioner with us, Commissioner Rice, who's been appointed since our last meeting. Dr. Rice, would you like to introduce yourself, say a few words?
Well, my name is Sheldon Rice. I'm employed at the University of Akron. I've been here about 28 years. Been in Akron for about 28 years. So just honored to serve, and thank you for the honor and the privilege to serve. Thank you.
We should at some point get our heads together, John, maybe, and do like a kind of an orientation about with the rules and the our procedures and sort of how we handle complaints and so forth, so that it all won't be a mystery as we start to go through these processes, and also to make sure
that would be helpful.
Yeah, and also to make sure that you have access to the Google Drive where we're keeping documents.
Right. Okay.
And I don't know if you've met everybody else. If you would, if you would just say your name and to introduce yourself. I'm Brent Lee. I'm the chair of the commission. We have worked together at the university on various diversity-related events. So it's nice to see you again.
Likewise.
Who wants to be next?
Hi, I'm Esther Thomas. I'm an attorney by training. I was also, and I was at juvenile court for 13 years or so, the majority of that as a magistrate. Currently, I am Director of Human Resources at Community Action, the premier anti-poverty agency in Summit County. It's a pleasure. Look forward to working with you.
I used to be on that board years ago.
Yes. Oh, so you know Malcolm. You know that.
I know
Richard,
Malcolm.
You know Malcolm. You know Richard. Yeah. Gang's still here.
Excellent.
I'm going to go ahead and call on Commissioner Pitt.
So Nanette Pitt, and I am vice chair of the committee or the commission, and also pastor at First Congregational Church of Akron. And as you can tell by the accent, I'm South African by birth, so an immigrant.
Thank you.
Commissioner Maddox.
I'm Gina K. Maddox, and I am with Leadership Akron, the premier leadership program in the city of Akron. And I am part of this commission, native of Akron, and also I used to work under Malcolm. So
Okay.
do I get any points for that? Okay.
Okay, yeah.
All right, years
just
ago.
long as you know that class 29 was the best.
No, class 13 was the best.
Oh,
Clear.
32. Always the best.
I direct the leadership, the Diversity on Board program here,
Okay.
where we train emerging minority leaders in the community for nonprofit board service.
Excellent.
And as it turns out, the first class of Diversity on Board was in fact the best.
Oh, come on, Brent.
Class 5 would argue.
John York and Yamini Atkins, do you also want to introduce yourself?
Sure. I'm John York. I'm an assistant director of law with the City of Akron Law Department. Yamini's my immediate supervisor.
Yeah, I'm Yamini Atkins. We are at the premier city of Akron, and the premier HR and the ACRC. So I did have the pleasure of meeting Professor Rice previously, and so welcome aboard.
Thank you.
All right, and we will proceed with the agenda. So the first item on the agenda is the approval of the minutes from the February meeting. Those were distributed by email. I'm going to do this thing that I saw somebody else do that I thought was helpful, which is I'm going to share them with you. I'm sorry.
Who's taking minutes? Oh, okay.
Oh, good. Do we have somebody?
Yeah, I jumped in. Yeah.
Fabulous.
Thank
Yeah.
you.
What I was saying is I saw this in another meeting and I thought it was helpful. I'm going to go ahead and share the minutes in case anybody didn't have a chance to review them. And after a minute, we can entertain a motion to approve the minutes.
I move to approve the minutes.
Is there a second?
I second Commissioner Maddox.
Fabulous. All in favor, say aye.
Aye.
Hi.
I will note that I'm going to abstain since I was not present. And the minutes are approved. We have two complaints of an old business which were being investigated. Do we have a report on complaint number 19 ACRC 13? That was Commissioner Pitt.
Yes, we do. I will. I'm wondering, since we aren't in person together, are we reading through them? Should I read through? How are we entering the reports?
I think in the past, the presenters have just given it orally.
Okay.
Whether you read it or whether you summarize it as you go,
Okay.
either.
All right. I'll do my best to summarize as I go. Otherwise, my 3 pages may take too long. So the complaint was the complainant was Mr. Kendrick Watson, the respondent Coca-Cola Consolidated. The complainant, Mr. Kendrick Watson, alleges that who worked as an order builder at Coca-Cola Consolidated, alleges that he was given 3 or 4 write-ups, and this is from my interview with him, 3 or 4 write-ups about leaving the work area to use the restroom under a waiting time called replenishment within the lingo of the company. And at first he was told then that he could not go to the restroom under that replenishment. Then he was told that he could not leave his work area without notifying a supervisor. However, he alleges that supervisors were not always near or the work areas, which you couldn't leave without permission. So it wasn't feasible to be able to notify them or find them. And so Mr. Watson and his co-workers would routinely use the restroom while on replenishment without notifying a supervisor. On one occasion, he was also written up for leaving his work area and for changing into shorts as part of his, in the last part of his shift. However, he said that he had been doing that for weeks, and he has a photograph of, and I should mention, sorry, at the outset that Mr. Watson is alleging discrimination based. He, on his complaint form, checked off both race and sex. Mr. Watson is a Black male. So he says that he has a photo of a Caucasian co-worker, Mr. William West, doing the same thing on that particular day, wearing short pants, when he was written up for changing into shorts. And at that same day, 2 co-workers had worked the whole day with shorts on. He was suspended for a day as a result of that. And when he went back to work, on the day that he went back to work, he left the floor, which he admits he is not allowed to leave his work area. But he's also not allowed to use his cell phone inside of his work area. So he left to take an emergency phone call from a realtor. Although his time was stopped, he was told that because he didn't notify a supervisor, he was written up, and that write-up, he was also fired at that time. He was let go. So Mr. Watson spoke about the supervisors as Mr. Richard Boney or Bonai, I'm not sure, and Mr. Jonathan Nicodemus. I actually didn't ask the gentleman how you pronounce his last name. Mr. Nicodemus, the supervisor who failed. There is an incident which Mr. Watson claimed began what he alleges was a targeting, and that was, he was not written up for that, but he left, one of the supervisors didn't call overtime, and he left because overtime had not been called. So he left on that shift, and he believes that was the beginning, and names that as a precipitating event, in addition to his having already been, had a firing for which was arbitrated, and he came back to the company a year before. So Mr. Nicodemus was the supervisor who failed to call the overtime, and Mr. Watson says that he treats African-American employees differently. Mr. Watson recalled an incident between Mr. Nicodemus and a co-worker named Ray, Mr. Ray Torrance, who's also a person of color. And the supervisor, quote, got in Ray's face about him not working, but the work system was down and the whole group of employees was standing around unable to work. So when interviewed, both Mr. Bonai and Mr. Nicodemus explained a connection between employees switching to replenishment time and the impact on productivity. It skews toward looking more productive inside of the computer system. Mr. Nicodemus stated in response to a follow-up question that he was not asserting that Mr. Watson was intentionally skewing his productivity. However, in response to the same question, Mr. Bonai responded affirmatively. Mr. Ray Torrance, who was interviewed, and another co-worker, Mr. Jason Fallgash, felt that Mr. Watson was targeted because all employees take time off the clock in the same way as Mr. Watson did without notifying a supervisor and under replenishment and are not disciplined. But when asked if he believed that the supervisors discriminated against certain employees based on race, Mr. Fallgash responded that he had not seen specific evidence, but that one supervisor, Mr. Jonathan Nicodemus, in quotes, doesn't have people skills. He's done things to me and others that are not professional. So Mr. Fallgash had also overheard two co-workers complaining to one another that Mr. Watson, the complainant, should not be allowed to cheat his time when another longtime employee had been let go over productivity around that same time. So he believes that the focus on Mr. Watson was the result of these two co-workers focusing on Mr. Watson and reporting him to the supervisors. When asked again about discrimination based on race with regards these two other employees, Mr. Fallgash stated, "I can tell you that both guys are white, and all I can say is they're the kind of people that if you get along with them, great, but if you don't, then they come against you." Mr. Bonai, the other supervisor, explained that there are always two supervisors on the floor and somewhere between 4 to 6 other individuals, and everyone calls them orange people or orange men because of the shirts they wear. They wear a different color Coca-Cola uniform shirt, who are available on the floor for employees to notify if they need to leave their work areas. In his interview, Mr. Nicodemus corroborated that, and he explained that there is also a dock coordinator who has a supervisory role and is either on the dock platform or closing up a truck nearby during the shift. So is always available to be notified if an employee needs to leave their work area. Mr. Nicodemus acknowledged that other employees do leave their work areas under replenishment, and he stated that he has had to address this and has addressed this with other employees too, and that he has seen a change in behaviors in his time as a supervisor. He asserted too that there have been a lot of violations of the uniform policy, and he explained that he has addressed this with individuals and that he works with them to ensure that they have the items they have the items they need provided to them. Mr. Bonai, who wrote Mr. Watson up for the uniform violation, asserted that he was not aware of anyone else violating the policy on the day that he wrote Mr. Watson up. Mr. William West, who was the other employee who Mr. Watson took a photograph of, affirmed that he has violated the uniform policy. He can recall doing that, and on occasion, and that he once received a warning for doing this. He said that he slightly recalls Mr. Kendrick getting written up for a uniform infraction and then coming to him and asking if he could please take a photograph of him because he was wearing shorts that day. Mr. West asserted that the rules changed, quote, changed a lot back then. In a follow-up question, he stated that they changed, quote, almost day by day, changing, quote, across the board all the time. He explained that employees don't necessarily know what they are until a group or person get a warning or disciplinary action. It appears that while there is a group meeting at the start of every shift, supervisors don't consistently use this opportunity to share or to clarify the rules and the norms that are expected. Mr. West said that they do, quote, sometimes, but it just goes by day by day, incidental as they choose. Another co-worker, Mr. Ray Torrance, shared that the expectations about uniforms were, quote, disorganized at that time. He continued on to explain to me that the division between company employees and union workers, that between them, you can, quote, feel the division between the two, and at that time, it was very toxic. There was a lot of miscommunication with a lot of managers and employees coming through, end quote. When asked about race-based discrimination, Mr. Torrance said, quote, certain, and that was particular, I asked in particular to Mr. Watson, Mr. Torrance said, quote, certain situations, yes, not all, but you can definitely feel the tension and how it is based on race on multiple occasions, close quote. So my, I don't know if I should ask for, well, my recommended finding, and I struggled with this finding, and I've discussed the case with you in some detail before, and I struggled with how to curtail my report too. So I'm happy to answer questions and have discussion. But let me share my recommended finding is that I could not determine reasonable cause to believe that the respondent, Coca-Cola Consolidated, engaged in discriminatory practice through the actions of its agents, in particular the supervisors, Mr. Richard Bonai and Mr. Jonathan Nicodemus. However, I find evidence in the accounts of the complaints of Mr. Kendrick Watson and his co-workers, the individuals interviewed, of poor communication by supervisors of workplace norms and rules, as well as inconsistency in the application of those norms and rules. In addition, cultural sensitivity training and team building would be a clear benefit to all employees, and I therefore respectfully urge the respondent, 1, to prioritize improved and consistent communication and enforcement of norms and rules, and 2, to introduce and/or increase the frequency, depth, and breadth of effective diversity and cultural sensitivity training, and to ensure that it is mandatory for all supervisors. I tried to curtail my report to only the incidences named by the complainant. I have a lot of other information shared by interviewees, and I'm happy to answer questions if I missed something, or if you would like to know more.
Is that the end of this part of their report?
Yes.
Thank you, Commissioner Pitt. I think that at this point, because it's relatively rare for us to get to this stage with a complaint, let me just review for the benefit of all the commissioners sort of exactly where we are in this process. When the investigator is done with their investigation, right, they present a report and make a recommendation. And the standard is whether there's reasonable cause to believe the respondent has engaged in a discriminatory practice. Reasonable cause, a discriminatory practice, right? And then what we are to do at this point is either make a finding as to reasonable cause or direct the investigator to continue the investigation, right? And we vote on that decision. So if there are, if there's additional investigation that we would like to see, and sort of could you find this out and come back? Or if we're ready to make a decision about whether we think there's reasonable cause, then we could vote on that, right?
Mr. Chairman?
Yeah.
There's one other option. There's a Rule 16I says that prior to making a determination on reasonable cause, the commission could decide that it would be appropriate to explore conciliation. So that
that's
would be
right. We had the voluntary conference idea.
Yes. So if you go that route, then there would be a conciliator. I think it's called a conciliation facilitator assigned, and I just wanted to point out that that's one other option. But I wanted to make sure to bring it to your attention before you voted on reasonable cause or no reasonable cause, because once you make that decision.
But is that
you can't go back.
conciliation, I'm sorry, John, is that conciliation option something that's done prior to the determination of a cause finding? Isn't the
Yes.
conciliation after the cause, if there's a cause
Well,
finding?
there can be a conciliation after if there's reasonable cause found, yes, then it would go to conciliation. But there's a specific rule that says, and it's Rule 16I, prior to the decision on reasonable cause, the commission can decide to try conciliation.
And what we called it is a voluntary conference that operates under the same rules as conciliation.
Correct.
I kind of remember when we talked about this, we wanted there to be a way to, have the parties meet and maybe hammer out an agreement, even in the absence of a finding. And then I just want to just briefly summarize, right? If we find that there's reasonable cause, whether or not we have that voluntary meeting before that or not, if we find that there's reasonable cause, then it goes to conciliation, and the parties are encouraged to reach an agreement. And then if there's no conciliation reached, right, then that's when we have a hearing, right? And we assign 3 commissioners to be a hearing panel, and that's when evidence can be presented, right, in a session. So just to sort of remind us where we are. Does anybody have questions for Commissioner Pitt about this matter to help them resolve whether or not they think that reasonable cause has been met?
Annette, this is Phil.
Is that Phil, Mr. Young? I thought I heard him start to talk and then.
Phil, I think you muted.
Okay, now it's unmuted.
There you go.
First of all, Dr. Rice, I'm Phil Young, the independent police auditor. They forgot about me, so I figured I'd jump in at some point.
I'm sorry.
That's all right.
How you doing?
Annette, you said there, in your report, there was 2 people that were wearing shorts that day. And there was one person that you interviewed that said he was wearing shorts. Is that correct? And they.
Correct. Mr. Watson did not name the other 2 employees.
Okay, was that subject black or white?
White.
And I guess my other question is about his union proceedings. Are they finished now?
Yes,
And the union terminated him?
they upheld the termination.
Okay. And it's my understanding he doesn't want his job back?
Correct.
Okay. It really puts a spin on some things on what he really wants, because when he says he doesn't want his job back, what does he want?
I did not ask that question.
Thank you. Very good report.
Any other discussion about this matter?
I do.
Commissioner?
Yeah, very thorough report. I know, Commissioner Pitt, you've been on the case for some time. I did have a question regarding the, in your recommendation regarding training and mandatory training of supervisors. I believe you said that there was also some room where the norms and workplace rules were not always communicated or communicated properly. And something else you said made me think that they weren't always applied properly or consistently as well. Given that, would you elaborate more about that if you, because I'm having a hard time, because lack of proper application of rules, workplace norms, and those workplace norms can be fair on the face, but if they're applied inconsistently, then there's problems. And so I'm just trying to, I share the the balancing act of what you're trying to address.
I think it is fair to say that across the board, Mr. Forgash identifies as a white person, Caucasian. Mr. Ray Torrance identifies as a Black man. So and there were other employees that I interviewed as well. And across the board, each of the employees reflected to varying degrees the inconsistency of the rules, the application, and the knowledge of those norms. Some said that it was a time when there was a lot of change. Others said that it was simply a statement of fact of the way things are run. While Mr. Watson did acknowledge that there are some basic understandings about not leaving the work area during your shift, not using a cell phone during your shift, it seems that all of the employees, to varying degrees, bend those rules from time to time in ways. And even the supervisors acknowledged that and asserted that they always continue to work with employees to address those things. And so in the instances that the complainant has raised that are the basis of this case is what I am finding, what I'm basing my finding on. And my limitation is my inability to step beyond those in testing. And so the scope of my investigation is limited to what is included in the complaint. It is not a holistic or evaluation of the practices of this respondent. Is that fair to help you to understand where I sit? If I had the tools and the resources to do a wide and deep look at this respondent, I don't, versus my task in this instance to consider these particular, that's the only way I've been able to pass those two things out.
Yeah. Oh, I understand, that perspective, and, and as, of course, to acknowledge you know, your time and energy and work and sorting through all of this, you know, that's considerable. I did just want to mention to Mr. Young's point about it was raised that the complainant doesn't want his job back. I think that's fine, because we might be in a situation where if there are these inconsistencies of norms and workplace rules, this situation can be repeated. And this is the, you know, without remedy or intervention. So that he doesn't want his job back, I think is his choice, but I think there's also room for the commission to impose training, mandatory training, you know, prior to that, have a voluntary conciliation, you know, those things. So, thank you.
I would add my comments to that. I do think that this commission is a little different from other bodies in the sense that beyond the wishes of the complainant, we have a goal of eliminating discrimination in the workplace, so that you know, the suggestions about other remedies being available. I'm not sure what our authority is to impose remedies unless we make a finding, right, of reasonable cause. I don't think that we do. I have a question. The way I'm looking at this, you know, in discrimination law, there's a principle that, you know, generally the complainant has to prove their case, right? But if you have a situation where, you know, a Black person is wearing shorts and they're fired, and a white person is wearing shorts and they're not, then the presumption switches, right? That the employer has to have some explanation. Why did they treat these two employees differently? And I'm wondering if, I'm not sure, maybe I should have been taking better notes. I'm wondering if you thought that in the, you know, in the supervisor's responses, did you see an explanation for why there would be that difference in treatment if there wasn't discrimination?
The employees of color with whom I spoke, well, the supervisor's response was simply that they were not aware that there was another person violating the uniform policy that day. The person's not under oath when they speak to me.
Did you find that plausible, or I mean, you do get to assess whether you think somebody, you know, whether you think people are being straight with you. Did you find that their explanation, you know, feasible? Did it seem as though it was commonplace in this workplace for there to be violations, and so that you would wonder why the supervisors wouldn't be aware?
Based on the body of interview or testimony shared with me, if I can use that word, based on all of that, I believe that the rules at this company are being applied inconsistently, and that people's personal biases and or racism, let's say it, may be showing through. I can't prove it, so I'm not going to say is, because of the inconsistency and because of the testimony given by the employees of color who feel that inconsistency, and this is my issue, is that there are other examples. The example that I shared, which both Mr. Watson and Mr. Torrance spoke to, of the day that that Mr. Nicodemus approached Mr. Torrance in the workplace, and the way in which those interactions happened. The testimony given is that there is a disconnect between different groups of people, whether it's the union workers and the company workers, whether it's the white workers and the black workers. There are disconnects, and that tension that was reflected to me is definitely being felt across lines of difference, including the line of difference of race. Now, the issue is around the uniform policy is that is not the only reason that Mr. Watson was fired. And that's where it becomes complex for me. And that he acknowledges himself that the uniform policy was different. And he acknowledges himself that he was not supposed to be using his cell phone in his work area or leaving his work area under replenishment, et cetera, you know. And so the firing itself in this complaint is not based on just the day that he wore the uniform. And unless, and as Mr. Ray Torrance says, unless I ask for every single, and we spoke about this before, whether I ask for the paperwork of every single disciplinary action taken by these supervisors, Mr. Torrance alluded to the intentional acts with some people getting disciplinary actions and some people not. And I asked, are you saying some people like white people and some people like black people, and there's the difference? He said, yes, but then he also asserted, so I said, so if I looked at the records of the disciplinary actions, would I see a pattern correlating to the employees of color? And he said, no, because what the supervisors do is when they become self-aware of what they're doing, they balance it out by then making sure that they write other people up. So the evidence I received is not, I cannot include that in an objective report or base findings on it because it's subjective, and this is about the culture of a company and about the practices of a company and things like, or at least that's where I feel it's headed toward, not something that is, so it's a struggle for me as a commissioner. Quite honestly, it's a personal struggle for me in terms of the reasons I want to serve as a commissioner and everything I stand for, and the greater sense of what I want to promote that you were speaking to, Commissioner Lee, about what we want to promote as a commission and how we get to execute that in the very factual details of each individual case.
I think that we have a difficulty with when we have had so few cases come to this point, right? That we don't have a, you know, when you get to make a decision over and over again, you start to work out what the standards are going to be and what the practices are going to be, and you start to develop a comfort with that, right? And ours have been so few and far between that every time we do it, it's like we're making up the world anew. Some of the things we're struggling with, you know, we have different lay person ideas about what counts as proof, right? You know, you may or may not be comfortable with being able to make inferences, right? Although I think in law, you often are, right, able to make inferences. As I was suggesting, right, in a situation where it looks like there might be discrimination, if the employer doesn't come forth and like the employer offers no explanation, you can make an inference, right, that there's discrimination. Now we don't have that here, but I think what you're characterizing as a difficulty with sort of making a subjective judgment, that might be sort of part of what is going on there. So let me say this at this point. You know, if there are more questions, then by all means. I think though that if not, then where we are is, you know, we're at the pleasure of the commission. I can think of three things at least that are options. Someone could make a motion that either that reasonable cause be found or that reasonable cause not be found, and we could vote that up or down. Somebody could make a motion that we try to implement the voluntary meeting provision before making a finding, and we could work on that. Or I also think that it might be, John, tell me if there's anything wrong with this. I think that one could suggest that we get an opportunity to review the written report. There were a lot of details that came out sort of kind of fast, and then put off a vote or a motion until the next meeting. Do you think there's that in bounds?
Do you have a feeling on that, Yamini? I don't think it's against the rules. I don't see any problem with that with the rules.
Yeah, I think, it would certainly make sense that, where these decisions be made, when people have had an opportunity they feel they have all the information they need to make a decision like this. So the recommendation that was provided was that by Commissioner Pitt is currently that there is no probable cause to proceed. Is that correct?
Correct.
Okay. And a report, and maybe have the report be shared with all the, did she send I'm sorry, did she send the report to everyone yet, or, okay. So
No,
I think it makes sense
so
to
what,
share, yeah.
yeah, what the chairman was asking is, can she provide the report, and then in the meantime, the commission would take time
Yeah,
and then have some more time to digest what they've heard and read the
yeah, I
report.
think that makes absolute sense.
Okay.
I don't think there's anything preventing them from doing that.
Commissioner Thomas.
Oh, I was, it might be premature, but I was about to move to make a motion that the commission receive the thorough and kindly prepared report by Commissioner Pitt for review with a vote at our next meeting.
Is there a second?
Second.
Is there any discussion? John, I did have one thought about this. I think previously the rules require that there be a report. And we have previously, I believe, received an oral report and not a written report, with the result that the investigators' notes are, it's not that they're private, but that they weren't, sort of formally presented to the commission. And I think that on this one, we're going to say, I think you can do it either. It doesn't say it has to be in writing, but it certainly could be in writing. So if we accept the report in writing, that document will have, I don't know, a different kind of status, I think.
It would be considered a public record at that point. Is that correct, yeah. John? Wouldn't it be considered a public record?
I think there's an exception for administrative investigatory work product. So we could certainly try and protect it to the extent we can.
Commissioner Pitt, yes.
So in Rule 16, number D, it says organization and documentation of records. Number 1, an investigator shall strive to keep a thorough and accurate account of each stage of the investigation process. I take that to include the report. All information gathered during an investigation shall be placed in a specific file that is updated on an ongoing basis. On the conclusion of the investigation, the file.
Can I ask who's here? Hold on a second. May I ask who is here?
Yep, it's Nancy.
Hi, Nancy.
Sorry, I don't know what was wrong with the link I was using. Apologies for the delayed arrival.
That's all right. I'm just making sure that we know who's in the room. So go ahead. So you were saying that you think that this will count as an investigative report?
I don't see.
Not as records, investigatory records.
Well, under the public records law, when we can verify it, but I think we did talk about this at one point, but those investigatory records are generally police records. So I don't know if there's an administrative exception, but we can definitely take a look. John mentioned something like that. So, but again, it's just something that you need to be mindful of that.
I don't think that, we can stand behind the document. There's no reason that we have to say that needs to be secret. It's your report to the commission. My opinion is that once it's presented as the report, then that would take that document, not all your notes and not all your out of the investigatory
Just the
notes
official document, yeah.
category. Just the memo. So that's just something to consider. Any other discussion before we vote on this motion? Nancy, just to let you know what's going on, Commissioner Pitt has presented a report on the case that was outstanding, and we have a motion to distribute the written report to commissioners to review prior to voting on whether there's a reasonable cause.
Very good. Thank you. I was just going to ask to have the motion read back. Appreciate it.
Oh,
How many reports have come to this point, Brent? Is it 3?
You know, I don't know. I know that there was one that went to conciliation, so that one certainly did. And there was at least one that that we voted no reasonable cause. I think maybe there's 2. So that would be 4, but that's an incomplete recollection. If we're ready to vote, again, the motion is to have the written report distributed so that we can vote on reasonable cause at the next meeting. All in favor say aye.
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 Any
Aye.
opposed? I hear none opposed, so that motion carries. All right, we have done substantive business today, Commission. On new business. Oh, and we don't have, Commissioner Mobley is not here to report on the other outstanding old business. Are we aware, John, that investigation is ongoing?
Yeah, that was the status at the last meeting. It was ongoing. And I have not heard from her since. So I've got to assume it's ongoing. Or she may, have a report ready. I just haven't heard.
All right, and I don't believe I saw any notice of any new complaints.
No, there are no new complaints.
All right, so consider amendment to the rules. Will you remind us where we are on this? Remind me where we are on this.
Sure, I'll do that. So at the last meeting, the commission voted to amend part of Rule 3, but there was an outstanding portion of that rule that we talked about, and I got some guidance from the commission. I went back, talked it over with Yamini, and I came up with what I provided you by email this week. Took it out of Rule 3 because it just didn't make sense there. And I proposed changes to Rule 14 and Rule 18. And it might make sense if I find that rule and figure out how to share the screen. Would you like me to do that?
Yeah, if you
Yeah, I
could
think that
share
would be
it.
great.
On the bottom of the screen, there's it says share screen, John.
Okay. I've got to find my document first.
You know what? I've got it. Why don't I
okay.
share it and you can tell us about it?
Sure.
Wait, is this it? That is not it. Sorry, I want to make sure I don't share the wrong document with you. There it is. So this is Rule 14, Conduct of Commission Business. And there at the bottom are 2 new paragraphs. Are you able to see that?
Yes, I am. Okay, so what the goal was here is to allow non-commission members to participate virtually. Because if you recall, the changes we made to Rule 3 in part were to allow commission members to attend and vote and conduct their business remotely. So that you wouldn't have to pass that motion every time. You just made it part of your rules. So what we're trying to do here is to allow non-commission members to participate. So this could include members of the public who might want to come in and make public comments, or it might include your guests who you'd like to speak or present on a certain matter. It just would require approval of the chair. So once someone asked to be able to participate virtually, if you approved of that, we would provide them with the Zoom link and they'd be able to attend. And then the purpose of subsection 5 there was just to make it part of your rules, the procedure you've already put in place on your notices. The notice of every meeting explains that members of the public can make comments through this email address. So I just added that to document the practice.
John, I have a question.
Yes.
Just refresh my memory. Do we have a provision in there for if we decide to go into executive session, how we would excuse any guests at that point? Is that something that Nina would control by exiting that person?
We do have executive session in your rules. I don't believe we've addressed that electronically.
Mm-hmm.
Nina, are you there?
I am. We could do one of two different things. The way council does it is there's a feature called Breakout Rooms, where what I would do is I would create a breakout room. I would put everyone that needs to be involved in it in that room. And then they could, when done, there's a button that you can hit to come back out of it. Or if it's something that still needs to be streamed, we could just put any guests into the waiting room and then bring them back in as needed. So, I mean, there's a couple ways you could do that.
Yeah, okay. We certainly wouldn't want to stream executive sessions, so we'd have to use the breakout room. But it's certainly something that could be addressed, Ms. Maddox.
Thank you.
Sure.
And let me share this again. This is the this is section 18. And it's a very similar, this is in the context of hearings.
Yeah, the goal here was just to make sure that any participants, parties, or anyone else really you wanted to approve, Mr. Chair, would be able to participate virtually.
So are there any, let me stop sharing this. Questions about the proposed amendments to the rules? Is there a motion to adopt?
So moved. Nancy
I
Holland.
see
Second.
Commissioner Holland. Commissioner Maddox is going to get the credit because she
Second.
found her unmute button. Any further discussion? All in favor of the proposed amendments to the rules, say aye.
Aye.
Aye. Any opposed? The amendments to the rules as proposed are adopted. There's an item C, that's consideration of a proposed amendment to the anti-discrimination ordinance. That that proposed amendment is still in the works, and we were going to hold off on our consideration of that until there's language to discuss. But that is I put that on the agenda because there was a possibility they'd be ready to discuss it this week. And then on community involvement and education projects, Commissioner Thomas, do you want to say something about this?
Sure. So at some point, the last Saturday in January, I was at attendance at a barristers meeting for those, the barristers of Akron Canton. And both Bradley Dunn and myself were there. And we said, oh, wouldn't it be great to do something with the ACRC, the barristers, Ohio Civil Rights Commission? Yeah. Well, very stunningly quickly, that turned into a CLE through the Akron Bar Association, moderated by Ed Gilbert, with Brad and myself being presenters. It was on a Wednesday, actually last Wednesday, the 20, last Wednesday, the 24th. And we had about 15 attendees. It was a webinar, and it was well attended and well reviewed. For the ACRC piece, I introduced the commission by name, who our founding chair and our members are, and then I sort of went through the statute about what that means, that established the ACRC and other things particular to Akron. And then I went briefly over our rules and how people might find us. There were some very excited lawyers when they realized that they could file with the ACRC, the OCRC, EEOC, and a particularly canny lawyer was like, "Oh, I see there's a provision for fees within the statute," and I said, "Only reasonable ones." So I think it was good. I told Bradley he and I should, or others should take this show on the road, and it was fun. So thanks.
Fabulous. Thank you for your efforts. As Commissioner Rice, one of the running topics in this commission is ways to make the public more familiar with what we do, and drum up maybe some more work for ourselves. So that's what that was about. What is this actually? Video PSA, community education efforts.
Is that regarding the
PowerPoint.
The PowerPoint that.
Oh, the
that was-
PowerPoint.
we sent an email to that effect. I think John sent it to all of you. So John, you want to explain what we were thinking about?
Yeah, we got Gina K provided me with her version. And then I got another email that there was an updated version. Was that from you, Nanette? Yes. Okay, so we thought it might be helpful to have a couple members, if anyone would like to help Yamini and I, maybe whip that into shape a little bit. And we thought it might be a good idea to keep it to a couple members so that we wouldn't create a public meeting situation.
I think we just felt that reviewing the PowerPoint, we had some procedural kind of comments that we thought could help clean it up, but we thought that any substantive messages that you want to share it would be beneficial to have a couple commissioners actually be part of the review of the PowerPoint. So it's the message that you all want to send. We recommended a few commissioners who I know have dealt with a lot of these. Esther Thomas has just spoken about, she's on training on it now. And I think Nancy Holland, I know, is been very actively involved in the OCRC. And I think Professor Rice also indicated an interest in this. So, I mean, you guys can discuss that, but we just wanted to keep it a smaller group and then, which can then be reported out to the commission.
Sounds like you have 3.
Yeah. I did, I'd be happy to help in any way. I did I reviewed, thanks Gina K, and thank you, Nanette, for providing the source document. I really like the plug and play aspect of it, that that there was a tailoring depending on the audience. And so I think a versatile document like that, where we are able to sort of plug and play, if it's, we could tailor it to our audience, would be great. And I'm happy to help with that. I did notice that our commission doesn't have our photograph in there. And because we were going to do that in April of last year. Yeah.
Yeah, that definitely needs to be updated.
That's a really dated
take a
photo.
Zoom picture?
That was one of our procedural comments.
Okay, everybody smile.
I'm not ready for my close-up, Nanette. I'm not ready for my close-up yet.
How do we do this in this new virtual world?
Yeah.
I don't know.
It'll come soon enough, I think.
Yeah.
Well, we can probably.
There's a way to do it in Teams.
I'm sorry. We can probably get, make,
Bruce
get in
Ford.
touch with Bruce, yeah, and see if he's gonna be available to maybe schedule something again, so. John and I can, John, maybe you can reach out to,
Are you talking about an in-person group shot?
well, I don't know how that's possible right now, but
Yeah, doesn't seem like it.
that's the other.
Maybe we
thing.
could do headshots. Because that would be easier to swap
Put 'em all
out. Not
together.
that you're not all gonna be here for a long time.
We can
You know, we had
swap
such
out.
turnover there. We lost like 4 members.
Well, you know, it might even be worth it to just make sure all the names are there, even if there's not a picture right now, because it doesn't represent the group right now. So at least have the proper identification, and then later we can, some point, maybe get a good group shot or something.
You know, have we ever even just, I mean, I bet some of you have headshots that we could just send in at least for the time being before we can take a group picture.
That
Who
might
should we
be an
send those
option.
to?
It's just how it
Yeah.
can be, if the IT can set it up like that. I don't know. We have to
Right.
check with them and see if that's something they could accept and put it up that way. I think
Okay.
there's a lot of changes they're trying to make to the website altogether, so but to see where they are with that, how they're doing it. That would be a good option, I think.
So who should we send our headshots to?
Well, we're gonna have to check and see, we have to contact our communications department and kind of see who would be responsible for. Ellen normally is the one, you haven't met her, have you met Ellen, Nancy? I don't know if you have, but
Yep.
she's usually the one that handles this aspect of it, so we'll
She
have
is
to see.
indisposed. Yeah,
Yeah, she's not able right now, but we can check and see who's available to help with this.
thanks.
All right, so it sounds like I don't think we need a motion for this. It sounds like we have a working committee that's going to work on the PowerPoint. I'll trust you to organize yourselves. And is there any other business? John, did we have any public comments come in?
Not as of 4:25 this afternoon.
In
So-
which case, I'll entertain a motion to adjourn.
So moved, Nancy Holland.
Is there a second?
Second, Gina K. Maddox.
All in favor say aye.
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 And we are adjourned. Thank you.